Smente? Ah, smente? Appena finito di... La mano è appena finito. Notice şuna, notice şuna. Şeyden değil. Junior Malaya, what?
May I please, Your Lordship?
Yes.
Your Lordship, I'd like to mention item 13 from the hearing list, Your Lordship. I'm mentioning on behalf of AIM, Your Lordship. Your Lordship, may kindly let this matter discuss after vacation, Your Lordship.
Okay. MS Tina Holly. Council makes a mention on behalf of MSAIME. The government advocate and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly.
Much obliged, Your Lordship.
Yes.
May it please Your Lordship? Lordship, I beg to mention item 11. I'm appearing on behalf of Mr. Suman Chetia, the leading counsel for respondent 2, 3, and 4. Since he has some personal difficulties to appear before this court today.
You're mentioning item
11. Hearing item 11.
on behalf of,
Mr. Suman Chetia,
is the counsel for the
respondent 2, 3, and 4.
CGC.
Yes, Lordship.
So this is fixed matter, let's see. Yes. Let's see the file. This is a fixed matter. What is the matter?
It's regarding the income tax matter.
Income
Regarding
tax.
the demands of the petitioner under Section 156 of the ITA Act. Lordship, the petitioner is since the petitioner is a ST, he's challenging the demand letter. The demand of 3 crore 17 lakhs 1,089,890 has been sent to the petitioner. They're challenging the demand, Lordship. He's not liable to pay since he's a scheduled caste, a scheduled tribe.
Yeah, younger, what is not in this case?
Younger was what is for the respondent one.
Is not in this case.
He's in this case.
Is not in this case.
No, he's in this case. He's for the respondent one. Union of India. Representing the secretary.
Okay.
Finance and Revenue.
And ma'am, you're for respondent number
2, 3, and 4.
Income tax department.
2, 3, and 4. Okay. You are the main party.
Lordship. Okay. The three department main party.
When do you want it?
Lordship, if a date may be fixed after 4 weeks.
After 4 weeks, a date.
Lordship, then in the first week of November.
MS. So. The Learned Council makes a mention on behalf of Mr.
Suman Chetia.
Suman Chetia, the Learned CGC.
Yes, Lordship.
The Learned CGC for the respondent number 2, 3, and 4, and 6 adjournment of the case for 4 weeks. On the ground that Mr. Suman Chetia, the Learned Counsel for the respondent, is an outstation lawyer and having personal difficulties to appear in the case today. The prayer is allowed, listed on.
Lordship, on 4th.
Listed on.
Indeed, is already
4.
4 Lordship.
Okay.
Yes, Lordship.
4/11/2024.
Much
I'll request my
obliged.
Lord. Lordship doesn't interim. Can you read continue?
The interim order passed earlier shall continue till the next returnable date. Okay.
I would like to.
May I please, Your Worship?
Yes.
Worship, I'd like to mention hearing item number 14. I'm appearing on behalf of my senior,
Who is their senior?
Mika H. Aye.
Who is their senior?
Mika H. Aye.
Oh,
Can you list this matter after 2 weeks?
item 14. Mr. Sensor, Learned Counsel makes a mention on behalf of Mika HIA. The Learned Counsel for the petitioner and seeks adjournment of the case for 2 weeks. Prayer is allowed. Listed accordingly. Okay.
Worship, there is an interim.
The interim order passed earlier shall continue till the next returnable date. Okay.
Worship. May I please, my Lord?
Yes.
Lordship, I may be allowed to make a mention for hearing item 12. Lordship.
Yes.
If it can kindly come up after 3 weeks, Lordship.
Here the counsel for the petitioner.
Yes, I have the consent of the respondent counsels, Lordship.
Mr. So-and-so, Santianga, the Learned Counsel for the petitioner seeks adjournment of the case for 3 weeks. Prayer is allowed. Listed accordingly. Okay.
Oblige, my Lord.
Your Lordship,
Yes.
item number 15.
The fixed matter.
Yes, Your Lordship, last Friday I filed one affidavit. So I need 2 weeks time for hearing out.
You file affidavit.
Yes, Your Lordship. Yes.
It is the other side who should seek time
Yes.
to go through your affidavit.
Well,
Yeah.
interestingly, that is the application for stay, vacation of stay. At this stage of final hearing the bills.
Okay. Yeah, Have you
Whether it's
have you filed your application? Have you filed your application for stay?
interim application, interim stay was granted to
Ah.
us. Now they filed after 4 dates. Stay vacation application alerts. A day prior to this hearing alerts on Friday itself.
Uh-huh.
So we have received a copy of that particular application. However, at this stage, I don't know if it is even maintainable or not, because this was the final hearing minutes, and the matter was listed for the last 2 occasions.
Okay, let us up to as per the list. Yes. As per the list.
Your Lordship, item number 3 is the same matter, Your Lordship.
As per the list, let it come. As per the list.
Lordship. Obliged, Lordship.
For motion, item number 1.
May I please, Your Lordship?
Yes.
My Lord, by the last order, I was instructed to obtain some instruction.
Yes, please.
Your Lordship, unless normal notice is issued, I think this matter cannot be disposed of as expected.
You are the additional AG. That is why we have confidence in you. That is why we told you to get instructions.
Yeah, there is a notification, recent notification, 2024. So, unless I obtain further instruction, I think this matter cannot be
It seems this notification came up after the writ petition has been filed. Also. So at this stage, if notice may be issued, I think. And I also have to go through the notification that was furnished to me by the Learned Advocate General this morning.
This is a little bit confusing, Mr. MT. Hmm. Although their name is entered in the electoral roll of
Yes.
1963, if they are not Nagas from within the state,
Yes.
indigenous inhabitant certificate will not
Yes.
be. Yes, Mr. Santri.
Yes, they are going back, Lordship, it seems. In 2024, by this 2024 notification, they have modified the conditions that has been laid down in the OM issued in 1977, Lordship, as well as in 2016, Lordship. But at this stage, Lordship, I believe since the additional advocate general wants to file affidavit, let him file his affidavit and then
Yes, yes.
I'll file a prepared reply.
Mr. Cynthia Amar, the learned counsel for the petitioner, and Mr. Intimson, additional advocate general, Nagaland for the state respondents. By the order dated 19/9/2024 passed by this court. The learned addition AG was asked to place instructions as to why the petitioner's name has not, the petitioner has not been granted the indigenous certificate,
Indigenous inhabitant.
indigenous inhabitant certificate, as per the notification dated 28/4/1977 and 2/2/2016, issued by the government of Nagaland, despite the petitioner's name being included in the first electoral roll of 1963.
Petitioner's parents, Lordship.
Despite the petitioner's parents' name, okay, parents' name being included in the first electoral roll of 1963. today, Mr. Imti, Mr. Imti Imsung, the learned additional AG, has placed the copy of the order dated 27/9/2024, written by the Government of Nagaland, Home Department, Home Branch, Nagaland, Kohima, which is reproduced herein below. This letter dated 17/9/2024. Okay. And the notification, and also the notification dated 29/2024. Okay, which is reproduced herein below. Okay, so two. In view of the letter dated, new para, in view of the letter dated 27/9/2024 and the notification dated 29/2024, Mr. The learned additional AG submits that he may be allowed to file a comprehensive affidavit in reply to the petition filed by the petitioner. Prayer for filing a comprehensive affidavit on behalf of the state respondents is allowed. Listed after 4 weeks. Okay.
For admission, item number 2.
Yes,
Lordship, I for this all responded.
who was the petitioner? Yes, madam, you're for the petitioner.
I was informed that the council will be appearing through BC.
Okay.
So,
Where is he? No, it's not there. We listed after the puja. Criminal. Okay. Although MS Lucino, the learned counsel for the petitioner, submits that the leading counsel, Mr.
Mr. Farouk,
Mr.
Farouk Khan.
Farooq Khan will be appearing for VC. The learned counsel for the petitioner has not appeared. In that way of the matter, listed after 1 week.
Obliged, Lordship.
For admission, item number 3.
Yes.
Your Lordship, this is the similar matter as item number 15. Your Lordship, the case has endorsed to me only last Thursday. So, Your Lordship, I may be allowed 2 weeks' time to prepare my case, Your Lordship.
Have you filed your affidavit?
Yes, Your Lordship.
Yes.
I do not object to this prayer that the learned friend needs some time to prepare. However, I'll just seek that a fixed date be given, because in a condition for the last two occasions, the date was fixed, nobody was appearing. If a warning in a form of last opportunity to the respondent be given, it would be so grateful minutes. Because for the last two occasions, the dates were fixed minutes. And I may be allowed to file a reply to this application as well, because at the stage of final hearing, stay vacation application is not itself maintainable minutes.
Have you filed your application for stay?
Yes,
Where is that? Huh?
Sir, we had filed this stay application. They have filed the application for vacating of stay on Friday.
So where is that on Friday? So
This Friday.
it's not there on the record. You have filed your this affidavit in opposition as well as the application. for
yes,
vacation.
Your Lordship.
Sir, this counter was filed back in June itself. Sorry, August itself. July, 24th of July. Now they have come up on this Friday with the application for vacation of stay minutes. Despite the fact, for the last 5 hearings, only on a single instance that they have appeared. If my lords may kindly have a look at the orders, they have only appeared on a single occasion, despite having the fixed dates.
Vacation of which order?
Order dated 1st of August 2024, along with the subsequent orders.
You have received the copy.
Yes, please.
Mr. Y.P. Gupta, the learned counsel for the
ED,
Respondent.
respondent.
yeah,
For the
sole respondent.
submits that an application has been filed with the registry to vacate the order dated 1/8/2024 as well as the subsequent order passed by this court. The application filed by the respondent is, however, not on record. The registry to trace the same and place on record. Listed on
Let's say if it be listed on 11th or 15th of November, it would be so grateful.
listed on 11/11/2024. Stop. In the meantime, the learned counsel for the petitioner shall file objection to the application for vacation of the stay. Listed accordingly.
Interim be continued.
Pardon?
In the meantime, let's the interim may continue.
The stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Obliged, Lordship.
So grateful.
For orders, item number 4.
Well, it's same with the item 15 as well, because both of the matters are connected.
Same order. Yes, Mr. Gupta. Is it same order
Yes, Your
for
Lordship.
item 15?
Yes, Your Lordship.
Okay, item 15, same order.
These minutes.
Okay.
Obliged.
item 15, same order. What is this?
May please, Your Lordship.
Well,
Lordship, here I have instructions to appear for respondent number 1 and 2.
who are the respondents?
There were 3 responded. 1 and 2 has been served now, my lord, as per the last order.
You are instructed to appear for?
1 and 2, my lord. I'll be filing my Bangla during the course of the day, my lord. So, I
What
may-
about 3 and 4? Who is 3 and 4?
Three, only three. Three has been three. Three is the statement. State has been submitted.
Oh, petitioner. 1, 2, 3.
I'm making for it.
Yes, Mr. KB?
Lordship. Lordship, state is more or less pro forma, Lordship.
Okay. What is the case?
My lord, it's a criminal crossing petition, my lord, where we have challenged the order of the magistrate, my lord, where a matter has been taken cognizance of, which is purely a civil dispute. My lord. There was an arbitration award, my lord, and award was in terms of payment of some money. Execution has taken the fact term of execution was suppressed before the court meeting, and this criminal proceedings were instituted, my lord, summons have been issued, and it is share out of vengeance and spite, my lord.
Maybe you are deliberately avoiding the payment.
No, my lord, we are.
If your intention is to deliberately avoid payment and then cheat somebody, the criminal element is there.
That is not there. We have filed an appeal against the arbitral award, my lord. That is being heard, my lord. It is pending. We have brought everything on record, my lord. And in the execution proceedings also, we have appeared and we will be filing our case.
Madam, you are instructed to appear for respondent.
1 and 2, my lord. I'll be filing my Bangla during the course of the day, and if I may be granted 4 weeks' time to file my countermand.
Mr. Your good name?
My name is G. Rahul, my lord.
So and so. Learned counsel appears for the petitioner. Stop. MS Lucino. Learned counsel submits that she has instructions to appear on behalf of respondent number 1 and 2. Have you filed power?
I'll be filing it during the course of the day, my lord.
And will be filing the power in the course of the day. She further submits that she may be allowed
4 weeks' time, my lord, to file my counter.
4 weeks' time to file the counter affidavit on behalf of the respondent number 1 and
1
2.
and 2.
Prayer is allowed. Listed after 4 weeks.
Can I pray for a date, my lord?
Yes. Listed after 4 weeks on. On 4/11/2024. Do you have an interim order?
I have been reviewed. My lord, can
Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
also can it be in the next week, my lord, second week of November? My connection is from Delhi.
Okay. You're on 12/11 instead of 4, 12/11/2024. Okay.
Obliged, my lord.
Deeply.
For hearing, item numbers 5 to 7.
Yes. What is this?
Lordship, this matter pertains to regularization, Your Lordship. Lordship, the petitioner here, Lordship, was appointed on the basis of land ownership. However, the appointment was contingency basis, Lordship. So the petitioner is approaching this court for the second time, Lordship. In the earlier petition, the petitioner has prayed for direction to regularize his contingency appointment and grant of scale of pay, Your Lordship. Your Lordship may find in the order at page 20, Annexure H, Your Lordship.
Which writ petition?
Same writ
Which
petition.
writ petition?
Lordship,
Which writ petition?
first writ, WPC 92, at page 21. I think you're allowed to read, Lordship. It's a short order, Lordship.
Which page?
Page 20, Lordship. Next year, H.
This is the first writ petition.
Yes, Your Lordship. WPC 92.
This is 2018.
Lordship?
This is of the year 2018.
Yes, Your Lordship. WPC 92 of 2018.
Yes, please.
Page 20, Your Lordship. I will be able to read the short order, Lordship. This is a writ petition praying for issuance of appropriate deed or direction directing the respondents to regularize a service of the petitioner as Chowkidar cum Sipur in the GHS Newland Dimapur and also to give a regular scale with restrictive effect for the last 3 years. It is submitted by Mr. I Long, General Counsel, that the petitioner was one of the landowners of the land on which the school, namely GHS Newland, was constructed and established. Therefore, as per the government scheme issued by memorandum such and such, 5891, she was appointed as Chowkidar cum Sipur on contingency basis, and thereafter her service has continuously been extended from time to time. The Learned Counsel further submitted that, as per the scheme, the landowner are to be appointed on regular basis, but the petitioner was appointed on contingency basis, which is in violation of the scheme. Therefore, the respondent will be directed to appoint her on regular basis as per the scheme. Mr. Along also submitted that an employee appointed on contingency basis are entitled to scale pay. Therefore, the respondents may also be directed to give her scale pay with retrospective effect for the last at least 3 years. As per the scheme, the Village Education Committee appears to have recommended the petitioner's case being one of the landowners. Further, it also appears that the claim of the petitioner was also recommended by principal of the school. And lastly, the additional Deputy Commissioner Newland has also certified to the effect that the petitioner is serving as Chowkidar cum Sipur of GHSS and is one of the landowners on which the school is established. In view of the documents stated above which support the petitioner's claim, the court proposes to dispose of the petition with the following direction: that the respondent shall dispose of the petition of the petitioner at annexure D of the petition in consonance with the scheme within a period of 2 months from today. So, Your Lordship, after this, Your Lordship, the impian order was passed, which is at page 22, Lordship. I may be allowed to read.
His letter.
Yes, Your Lordship.
Yes, please.
I may be allowed to read, Lordship. With reference to the subject cited above, it is regretted to inform you that the department is not in position to consider your representation dated such and such in consonance with the government scheme dated 5891 as you cannot claim the right to be treated equally with other employees appointed on landowner basis as they were appointed against a sanctioned post, whereas in your case your appointment is on contingency basis without a sanctioned post. So the government is saying that since my initial appointment was on contingency basis and without a
What
sanction
is
post,
this 5891 notification? What is this
this is a
5891?
memorandum with regard to appointment of landowners, which was in force at that point of time, Your Lordship, when the petitioner was appointed, Your Lordship, 91.
When was the petitioner appointed?
2007, Your Lordship.
2007.
7. Yes, Your Lordship. So at that point of time, this memorandum was in place, Your Lordship.
Please read this in Q order once again.
With reference to the subject cited above, it is regretted to inform you that the department is not in a position to consider your representation dated 5/3/5/2017 in consonance with the government scheme dated 5/8/91, as you cannot claim the right to be treated equally with other employees appointed on landowner basis, as they were appointed against a sanction post, whereas in your case, your appointment is on contingency basis without a sanction post.
What this letter conveys is that the other landowners were appointed
On
again.
a sanction post. Lordship, I should have been appointed in a sanction post in the first instance, Your Lordship, on a regular basis, Your Lordship. However, they appointed me on contingency basis, Your Lordship, which is why I filed this earlier writ petition, Lordship. And
On landowner basis.
yes, Your Lordship, I was appointed on landowner basis, Lordship, but it was a contingency appointment when it should have been a regular appointment, Your Lordship.
How do you say regular? Where is that government's notification to say that
Lordship.
landowner should be regularly appointed?
Yes, Your Lordship. Annexure A. It is the memorandum, Your Lordship.
Page
13.
of this writ petition.
Yes, Your Lordship.
Page 13.
Page 13. Lordship, we kindly come to point number 5, Your Lordship. Yes, Your Lordship, got it. Point number 5. Written as grade 4 post, Your Lordship. Point number 5, Your Lordship.
But whether this 1991, whether this letter is still in force?
Lordship,
Who has written this letter? Who is the authority?
this is a memorandum of the Directorate of...
No, this is not a memorandum. Your page 13. This is only a letter. This is only a letter.
This is by Under Secretary School Education, Your Lordship. At that point of time, this was enforced, Your Lordship, with regard to landowners, Your Lordship.
Yes, Madam Inauli.
Yes, Your Lordship.
Whether this 1991, this letter, whether this has any relevance?
Your Lordship, for especially with regard to education department, this was in operation, Your Lordship. However, Your Lordship, even before that, there was this government memorandum of 1977, Your Lordship, where it says that, Your Lordship,
Please just explain. Don't give me anything. We'll see to the when I hear your submission.
okay, if I may be allowed to read, Your Lordship. It is known fact that in the beginning, when the administrative headquarters and block headquarters were set up in various parts of the state, the public were very enthusiastic to have this establishment in their respective areas. And for that, there were no competitions among the tribes, areas, and range offering lands of such other facilities free of cost. Many of the administrative centers and block headquarters were established on lands donated free of cost by individuals or parties after executing agreements between the parties concerned. It is now been brought to the notice of the government that certain parties or individuals who have been in the beginning given land to the government free of cost for the development of the areas are now coming with claims of land compensation for the land which they were originally donated to the government by their free will. No claims of compensation for land which were originally donated to the government will be entertained by the government. Boundaries of such land or area originally donated should immediately be demarcated on the ground and should be surveyed with the help of Land Records and Survey Department of the state. If it has not been done so in all cases of demarcation, execution of agreement regarding donation of land, assistance of government servants or public leaders who were present at the time of setting up the administrative centers of block headquarters or area given free of cost by the individual or parties should be obtained. Copies of agreements executed between the government and the individual parties should be maintained properly and copies sent to the Land Revenue and Records Department freely and safe for safe custody. Your Lordship, there is no agreement in this case, Your Lordship.
So what happens to the latest notification 2018? Every
It's the-
time a landowner, then you bring 1970
It still
notification,
exists, Your
you bring
Lordship. And Your
1991
Lordship, even
notification.
as per the latest OM also, the petitioner is not eligible, Your Lordship, because all these petitioners are related, Your Lordship. I will show you, Your Lordship. If you can, in WPC 92, Your Lordship, if you can turn to page 12, the affidavit, Your Lordship.
No, we will hear you, but
Yes, Your Lordship.
I am just inquiring whether all this 91 letters and all this will be applicable for appointment of landowners, because government has come up with an
Yes, Your Lordship.
after a long time, government has come up with a notification 2018. So if you have to say that this also is applicable, that is also applicable, those are also applicable, then which
No, Your Lordship.
office memorandum or which letter this court will rely?
As of now, this will
The
exist
government is
2000
confusing
2018,
actually.
Your Lordship.
Government is creating confusion. If you have come up with a notification, then that should be in superstition of all the letters or notification issued earlier. See,
Your Lordship, if I may, Your Lordship.
yes.
As far as this petitioner is concerned, Your Lordship, 91 notification will apply, Your Lordship, because he was appointed 2007. The latest memorandum will not have retrospective effect on the petitioner, Your Lordship. Lordship is aware, Your Lordship.
But you are seeking appointment prospectively.
Lordship,
You say that okay, there's the latest memorandum will not apply,
yes, Your Lordship.
but your claim is prospective.
Basing on the 91 memorandum.
That is why.
Memorandum, Your Lordship.
Now, how
Because I
can we
was
give a
appointed-
retrospective effect to that 91 when there is a notification 2018?
Because I was appointed in 2007, and that at that point of time, the notification in force was 91, Your Lordship. So, as per the notification, I'm entitled to Lordship. And at that point of time, all the landowners were appointed as per the notification, Your Lordship. So, why treat me differently, Your Lordship? This is discriminatory, Your Lordship.
What is your position now?
I'm still.
You are still
continuing
contingency.
Contingency on fixed pay of 2,000 per month, Your Lordship. The government in the affidavit is saying that at that point of time there was no sanction post. But because of exigency of service, they have appointed me on contingency basis, Your Lordship. However, Lordship, it's been 2007. It's been more than 15 years, Your Lordship. I'm sure there was vacancy, Your Lordship. Solely if they are saying that there was no sanction post at that point of time, Lordship, a direction may be given as when vacancy arises. I may be accommodated in a sanction post, Your Lordship, in a regular post, Your Lordship.
Thing is that whether you have that right, this court is confused.
Lordship, I'm the landowner. I'm one of the landowners, Your Lordship. 300 acres of land was donated, Your Lordship, for establishment of new land.
You are the sole landowner.
No, I'm one of the landowners.
One
Your
of the
Lordship.
landowners.
Yes, but it's
The
a
others
big-
have been compensated
it's
with
a-
appointment.
It's a big,
The others have been compensated.
not all, Your Lordship. Lordship, what happened was that, I stated in my affidavit also. First, middle English school was established, Your Lordship. I said it in my paragraph 4 of my affidavit in reply, Your Lordship. Your Lordship may come to my affidavit.
When have you given the land?
In the year 1987, Your Lordship.
1987. That time you have donated. That time you have donated. Now seeing that the value of the land is has become precious, you are actually trying to blackmail the government.
No, Your Lordship. I was appointed on the basis of land ownership by the government, Your Lordship.
Anyhow, we will examine your claim on the basis of 2018 notification issued by the government. That is the latest law prevailing. That is a policy taken by the government.
Lordship, whether 2018 can have retrospective effect, Your Lordship.
Ah,
Whether that can happen. Because I was appointed when 91 was enforced.
Yes, you were appointed in 91. Now you are claiming regularity.
Lordship, see,
You are claiming regularization. What is the year now? 2024.
Lordship,
What is the notification? 2018.
Lordship, in the first place, the government should have appointed me in a regular post.
Not necessarily. Not necessarily.
Yes, Your Lordship. Because
And all these letters, these are only directory, not mandatory.
and even going by the other
We are not giving you
notification,
relief, ma'am.
Lordship, even going by the other notifications also, then no appointment is on regular basis, Your Lordship. No way it says it should be contingency, Your Lordship.
This is only a
And it is
letter,
not-
nothing.
It is not disputed that I'm not. It's not disputed that I'm the landowner, Your Lordship. They have not said anywhere that I'm not the landowner, Your Lordship.
Okay, this 42. What is 90? What is 90? This thing. 93.
92 is Chokidar for the post of Sipur come Chokidar. 93 is beyond, Your Lordship.
Peon. Why different post again?
This is this is different petitioner, Your Lordship. This is the post of peon, Your Lordship.
Your Lordship,
Same petitioner.
No, Lordship.
they are all related, Your Lordship.
This is different petitioner. Your
One is the wife of VK Jimo, one is the son of VK Jimo, and one,
Okay.
the affidavit, there's a typographical error in the affidavit, which should also be corrected, Your Lordship. In
So
WPC
92 also for regularization, 93 also for
Yes,
regularization.
Your Lordship. They were all appointed on contingency basis on the basis of land ownership, Your Lordship.
Son of WPC 94.
Come to your prayer. Caution set aside the letter bearing
Yes, Your Lordship. The letter by which my representation was cancelled. Is cancelled.
then direct the respondents to regularize the service of it regular state.
The petitioner is also praying for scale of pay, Your Lordship.
Petitioner is claiming
Scale of pay, Your Lordship, because the petitioners is
where
discharging
have you stated where is your agreement that you discharge similar duties? Where is your agreement?
I stated in paragraph 8, Your Lordship. Eight, Your Lordship. Also in paragraph 17 as well, Your Lordship. 8 and 17.
8 and
17.
32. 8 and
17. Paragraph 8 and 17.
8 and 17.
Yes, Your Lordship. The state respondents have not denied it.
Okay, we may have to think over whether you are entitled to equal pay for equal work, but so far as regularization, this court is firm. No.
Lordship, at least if there's no sanction posted, if the action may be given, if in future. if
No,
sanction
you are
was
not
given-
entitled.
Lordship.
You are not entitled to that. What in your affidavit have you stated for this letter 1991? What have you stated? Yes, government advocate, what have you stated?
Lordship, I've also relied on this latest OM, Your Lordship.
No, what have you stated this? You are the one, the government is always the one who is creating confusion.
Yes, Your Lordship.
What have you stated on
Your
this?
Lordship, it's at para 5, Your Lordship.
Page 13.
Page 2, Your Lordship.
No, their affidavit, para 5.
The replies in paragraph 5 of the paragraph 5.
Yes.
They replies in paragraph 5 to my paragraph 3. They're saying that that policy does not give any entitlement for contingency employment to claim for regularization. That is
And the problem is that government, do you understand what is a policy? What is the policy of the government? This is not a policy of the government. This is just a simple letter written by the department.
Yes, Your Lordship, but we've also relied on the policy, Your Lordship.
They've also said that
Para
it's a
7, Your
memorandum,
Lordship. Para 7, Your Lordship.
Lordship, in the affidavit, they've also said that it's a memorandum. And towards the end, they've said it's a policy laid down for the recruitment of employees, Your Lordship.
This letter,
Yes, Your Lordship.
if the government says it's a policy, will this court accept? This court is not so blind. The letter written by the department cannot become a policy just because the government says so.
But Lordship, at that point of time, all the landowners
No.
were appointed on the basis of that. All the landowners in the Department of School Education was appointed based on this letter, Your Lordship. At that point of time. All the
Okay,
others, Your
maybe at that point of time some wrong has been committed, but we cannot give you the benefit of that wrong now.
Lordship, 91 notification is not illegal also, Your Lordship. It's not
This is not notification, ma'am. This is just a letter. It's just a letter written by the Under Secretary School Education to the director.
Your Lordship, in my para 7, Your Lordship, we've stated that since there is no agreement between
And this notification is not related to only grade 4 posts, Your Lordship, but others also, graduate teachers as well as recruitment of drawing teachers, LDA typists, all is there, Your Lordship. So it can't be just letter, Your Lordship. Let's hopefully continue, Your Lordship.
For any appointment, we rely on 2018 notification regarding land owners. That is the policy decision of the government. This is a simple letter.
Okay, then as per the letter, there's a line where the DC needs to verify, Lordship. In this case,
No, don't jump to that. Don't jump to
There
that.
is no
if you're relying on
agreement.
2018, then they can verify whether I'm the landowner or not, Your Lordship.
There is no oral agreement or written agreement. There is no statement. saying that.
1987, you donated the land,
Yes, Your Lordship.
and then the government has come up with a notification in the year 2018. And then you are now saying that allow us the benefit of that notification, where actually the deputy commissioner has been directed to make necessary verification.
So here as per my petition, I'm saying that I'm
Where is the document to show that you have donated the land? Where is the document?
No, the ADC is also the ADC, the village council.
No. Where is your agreement? Where is your agreement to show that you have donated the land? You have donated the land free of cost to set up the infrastructure of the government during that point of time. Now realizing that the cost of the land has become precious, you are actually coming into the picture to claim a grateful appointment.
It was the government who
We
has
will not allow you.
They were appointed. It was the government who has appointed me on that on basis, Your Lordship.
There's nothing to show.
Because the only way I'm entitled to be appointed a grateful post is because I'm then on a Lordship.
If the government commits wrong, this court will not actually commit another wrong again. Let's see your appointment order.
Page 14. Page 14. Page 14. Make sure. Srimati Ahuli Sema is appointed as Chokidar cum sweeper on contingency basis at fixed fee of rupees 1,500 per month at GSS Newland under establishment of DAO Dimapur for a period of 1 year with effect for such and such election. The appointment is temporarily purely on contingency basis. It is necessary and recommended if found absent for duties without prior notice. Thereafter, it was extended from time to time.
Where is the thing to show that she was appointed on land ownership basis?
Actually, in the appointment order, there's nothing. Even in the other cases.
How can you import something which is not there in the order?
Because, but Lordship, in every case, Lordship, where someone is appointed landowner, nothing is written in the appointment.
No. Don't talk about the others. Talk about your case. Talk about your case. It's not mentioned there. You are trying to import something which is not there in the order, and this court will not believe that.
Lordship, even the government is not denying that I was appointed. I'm a landowner, Your Lordship.
This court will go by the records. You see.
Even the principal, the ADC is also, and the GB of the village council is also certified that I'm the landowner.
They will certify 101 landowners. They will certify 101 landowners. That doesn't mean that the 101 landowners should be appointed. If that is the case, what is the right of the others under Article 14, 16?
I'm saying that as per the 91, I'm qualified, Your Lordship, that if the government is relying on the latest memorandum, then I can verify it, Lordship. And if I'm eligible, I may be given a regular appointment if vacancy arises in the future, Lordship.
Yes, we are discarding this 1991, this letter. On the basis of this letter, we cannot give appointment to landowners. If not, there will be numerous of landowners coming claiming for appointment on the basis of this 1991.
Lordship, what we are saying is that now they cannot claim it, But I was appointed in 2007 when this memorandum was enforced. 2018 was after my appointment.
You are claiming after the 2018 notification.
Lordship.
You are now claiming.
No, they are saying that 2018 will apply to me. But I'm saying that 91 will apply to me, Your Lordship.
91 is just a simple letter. 2018 is a policy decision of the government. That this court is well
All
conversant.
the well-owners during that point of time was appointed
No,
through 91 years.
we are not allowing your application. Yes, tentatively, I have decided my mind not to allow your application. Yes, government.
Your Lordship, here I would also like to draw your notice to the affidavit, especially with regard to WPC 92, Your Lordship.
WPC?
92, Your Lordship.
92 years, I'm on it.
Yes, page 12, Your Lordship, the affidavit, Your Lordship. I, Mrs. Aholi Sema, age about
Page?
Page 12, Your Lordship.
Page 12 of your affidavit.
No, Your Lordship, the writ petition, Your Lordship.
Oh, writ. Yes.
Yes, Your Lordship. I would like to read. I, Mrs. Aholi Sema, age about 33 years, wife of V.K. Jimo. This V.K. Jimo, Your Lordship, this is important. Resident of Vito Village, Newland District, Your Lordship. And even in WPC 93, Your Lordship.
Then why?
I'm drawing attention to this, showing that all the three petitioners are related to this V.K. Jimo, Your Lordship. One is the wife, one is the son. But with regard to 94, Your Lordship, there's some defect in the affidavit. It's written, I, Srimati Anila Sema, age about 40 years, son of V.K. Sema. So, as per this OM, Your Lordship, land ownership cannot be claimed in perpetuity, Your Lordship. And here the petitioner is claiming regularization on the basis of, Your Lordship, land on.
I have still not understood what you are submitting.
Your Lordship, all the petitioners, these are tagged together, and all the petitioners are related to one V.K. Jimo, Your Lordship, who is who seems to be the descendant.
V.K. Jimo has been appointed?
No, Your Lordship, he's the in WBC 92, Your Lordship, Aholi Sema. She's the wife of V.K. Sema, Your Lordship. And in WBC 93, Tokato Jimo, he is the son of V.K. Jimo. And in WPC V. Anila Sema, she's the, here it's in the affidavit.
WPC V. Anila Sema, what is that again?
WPC, sorry, Your Lordship, 94, Your Lordship. The petitioner in WPC 94, 2000.
94 is not here. Oh.
Here, Your Lordship. The petitioner is the.
Let us see the affidavit 93. Let us see how you are actually trying to justify your case. 93.
Your Lordship. That's also in page
Tokato
12.
V.K. Jimo.
Yes, Your Lordship.
Then 94.
In 94, it's written son of V.K., Your Lordship. Though the petitioner is a girl, Your Lordship.
94 is V. Anila Sema, aged about son of.
V.K.
It should be daughter of.
So one way or the other.
The daughter is older than the father. Huh?
Here the father is not before the.
This is V. Anila, so and so, son of V.K. It should be daughter of.
Yes, Your Lordship.
Sure. This one.
Huh. Tell her to correct. So, what is the importance
Your
of being
Lordship-
the son, wife, daughter of Vikesh Emma?
So, Your
Vikesh
Lordship-
Jimomi. Who is Vikesh Jimomi?
He's the landowner. So they
Ah.
are the wife, son, and daughter of the landowner, Your Lordship.
Yes.
So what I'm saying is, as per 2018, Your Lordship,
Whether Vikesh Jimomi or anybody has been appointed.
Your Lordship, we're saying that in our affidavit also we're saying landowners have already been appointed, Your Lordship. But we're saying that as per this 2018, Your Lordship, the landownership, the appointment cannot be in perpetuity, Your Lordship.
Yeah, that this
So,
court is well
as far
aware.
as Your Lordship, there's no, in this case, Your Lordship, particular case, there's no agreement, there's no written agreement, there's no oral agreement also with regard to employment, Your Lordship. And as per this OM 2015, Your Lordship, I would like to, Your Lordship is well aware, but I would like to read to, it's in my
18,
affidavit. Yes,
15.
18 OM, Your Lordship.
Ah,
Close to, Your Lordship.
ah.
All cases where administrative headquarters and block headquarters were set up in various parts of the state on land donated freely by individual villages or people of that area should not be reopened or compensation or for employment in consonance with the policy brought out by OM 26 1977, Your Lordship, which I already read out. So in this case, there is no agreement, Your Lordship. This was freely donated, Your Lordship.
So the
Your
wording
Lordship,
itself
there's no
shows
claim.
that the policy will have retrospective effect.
Yes, Lordship.
Lordship, this petition is not for fresh appointment, Your Lordship. They've already appointed me.
All the three you have appointments.
Yes, Your Lordship.
All the three contingency appointment.
Yes, Your Lordship.
All the three.
Lordship.
In all the three writ petitions, the petitioners are appointed on contingency basis.
Yes, and it was appointed by the government, Your Lordship. They've appointed me on land.
But it's not on land on
Because
basis,
like
Your
I've said
Lordship.
earlier, Lordship, the only way I'm entitled to be appointed in this grateful appointment is because I'm a landowner, Your Lordship.
The
And
department
it's-
itself is
the
not clean,
The department
Mr.
itself is appointed me, Your Lordship. And Your Lordship, there is in the land donated by my father, Your Lordship.
Who is the landowner who has been appointed as per the government?
Your Lordship, those documents are not there, but in my affidavits saying that 4 landowners have already been appointed in that particular.
Produce those
plot of
documents.
land.
Produce those documents. Where have you stated?
Your Lordship, in para 5, Your
Of
Lordship,
which affidavit?
of my, in WPC 92, Your Lordship, it's at para
Just wait. The
Para
WPC
92, it's at para 5, Your Lordship.
para
Para 5, Your
Your
Lordship.
Lordship.
the petitioner was appointed. No, para 5
Of the government affidavit.
of the government. Yes, ma'am, please
Your
read.
Lordship, I would like to read paragraph 5. That with regard to the statements made in paragraph 3, 4, 5, 6, 7, and 8 of the writ petition, the answering deponent respectfully states that the petitioner was well aware of the policy laid down for the recruitment of employees in the Department of School Education by such and such 5891. The government had already given appointment to 4 landowners in Government High School Newland against existing sanctioned posts of grade 4 posts. However, in the year 2007, the department had upgraded Government High School Newland to Government Higher Secondary Newland, and the upgraded GHSS has no more vacancy or sanctioned posts in grade 4 pass. But due to the exigency of the upgraded school requirement, the department had appointed the petitioner to the post of Chokidar cum sweeper at JS on contingency basis at fixed pay due to non-existent sanctioned posts. Therefore, the petitioner cannot claim regularization of service with regular scale pay after a decade when the Your Lordship, this might not be necessary. But with regard to that, Your Lordship, 4 landowners have already been appointed.
You produce the documents. You produce this the document. If you are making an amendment, In the affidavit, obviously there must be some documents. Produce it. And madam, you were appointed on your exigencies of service. It's very clear. Add MS Esther, the learned counsel for the petitioner, and MS Inaholi, the learned government advocate for the state respondents. Stop. In the course of hearing, the learned government advocate has submitted that 4 landowners have been appointed on the basis of land ownership. Stop. However, no documents, no the appointment of the said landowner, the appointment order of the said landowners has not been enclosed, nor any documents produced to substantiate the same. Stop. This court desires that the learned government advocate shall on the next day produce the appointment order of the landowners or any official documents which will show that landowners have been appointed to grade 4 post against the land acquired in the context of the present case. We are leaving it as part listed as a part item on (15, 10, 20, 24). Okay,
You'll still through a document, right? No affidavit.
pardon?
Just the document, right?
Just produce the order.
Okay, then.
Okay,
15 is fine.
you just produce the orders.
Much obliged.
Okay. Yes.
For hearing, item number 8.
What is this case, Mr.
It's
CT?
a very short matter.
What is that short matter?
Petitioner is aggrieved by a summon letter issued by the village council.
Huh? Someone letter issued by the
Village council in connection with allegedly in connection with the land dispute matter issue. So the petitioner is questioning the summons on the ground that the village council court, there is no constitutional village council as a court. Yes, village council is there for administration of the village, but it cannot be function as a court so as to decide the land matter. Because Lordship is really aware
where is the land?
that
where is
is
the
an irrelevant village.
That means Dimapur.
Yes, and it is coming under Dimapur Mauza. And if at all, I'm saying that there is no land dispute, but if at all there is any land dispute, it is a cadastral area coming under a cadastral area within the Dimapur Mauza. Therefore, it is the deputy commissioner.
Yes, yes.
It is the deputy commissioner who can adjudicate such a dispute. And so far as village council is concerned, village council is there, but not as a court. because Lordship is well aware, the government has constituted three tiers of customary courts. Village court,
Is that? Excuse me for 5 minutes. Yes, Mr. City.
Lordship is well aware about the village concept, the composition. The government has constituted the customary court at three tiers. Village court, that is the village council court, and the sub-divisional customary court, and the district customary courts. That has been kept in abeyance by the government and it has not been enforced.
Correct.
Therefore, as a court, the village council cannot function. In other words, it is not a constitutionally recognized court in the IAP law.
It is a statutory body.
Yes, it is a statutory body, no doubt, and they have all the powers to administer the village. So I'm aggrieved by the summons letter, straight to the point, to the Indian order lordship.
Mr. City,
Yes.
can we just flip through the administrative
Thanks.
powers of the village council?
Yes.
What the village should do, what the village council should do?
Just a minute. This is under section 15,
Just
village administration.
village council. Village council. Powers and duties. Correct.
Village administration.
Village.
Powers and duties is
Is it?
section 12. And the village administration is section 15.
Mr. CT, just assist me.
Not
Section 14 was deleted. What is section 14 was? I think that is is it the adjudicatory power of the village council?
yes,
Adjudicatory power.
yes.
But where is that original section 14?
Page number 8.
Next,
Page number?
next page number 8 on the top.
This book
Yes, that compilation.
to transfer the village council shall administer justice within the village in accordance with the custom is accepted by the council in case of dispute between falling in different areas and so. This was this section 14
Yes.
was omitted by which amendment?
It was in 1989. 87.
It was deleted by the Nagaland Village and Area Council Amendment Act 1985.
Which page are you reading?
That is page 7.
Page 7.
Just above the statement of objects and
Okay.
results.
Just section process was deleted by the okay. This administration of justice, correct?
Yes.
The provision of it was deleted by the Nagaland village and area councils and so for the purpose of okay. So now what are the powers and duties? That is in
Powers
section
and
12.
Duties is yes, section 12. This is mostly for development of the village.
If we have to provide security,
How the funds are to be utilized. You know, this.
Okay.
In view of that, a village council cannot be recognized as a court. They have all the powers for administration, for maintenance of law and order. I concede to that. Yes, they have. So coming to the present case, what happened? In 2014, the respondent number 6, respondent number 1 to 3 is the government, respondent number 4 is the village council, respondent number 5 is the mother, and the respondent number 6 is the son. Now
5
the
and 6 are
petitioner-
mothers and son.
Yes. The present petitioner is a resident of Oka. So, respondent number 6, the son is having a big chunk of land in Irrelevant village, about 26 acres. So, he is from Karo community. He wants to dispose of some of his lands. So, in that connection, he has taken a sum of rupees 5 lakhs from the present petitioner, were taken in 2014. And thereafter, in the next year, another 50,000 was taken. So altogether, 5 lakhs, 50,000, 70,000 was taken by the respondent number 6 from the petitioner. And there was a deal that I should assist him in selling his land because since he being a Garo community has some problem. So he has approached me.
That the petitioner will assist the respondent number 6.
Yes, in selling his land. In that connection, there were some negotiations. And then it was advertised in the newspaper by the petitioner for selling respondent number 6 land. It was published in the paper for disposal, for sale. Now, after that, the writ petitioner insisted for furnishing a Xerox copy of the land documents to the petitioner. But then he has declined to hand over the Xerox copy of the land documents. Therefore, when it was pending, the village council issued a summon notice to the petitioner. So the petitioner is coming before this honorable court, questioning the legality and validity of the summon order issued by the village council as a court. That too, the point which is mentioned in the summon order is a land dispute. But so far as that is concerned, the petitioner has categorically stated that there is no land dispute whatsoever, and if at all there is any land dispute, such a dispute can be decided by the deputy commissioner who has issued the land pata and everything, and not by the village council itself. So I'm not a resident of that village so as to succumb to the jurisdiction of the village. I'm a resident of Oka. Therefore, I'm questioning the summons letter issued by the village council of Irrelevant village to appear in a land dispute case. So that is the whole crux of the matter in the case. If necessary, I will take your lordship to. Only 3-4 documents are there: the receipt and the summons including letter, lordship. Can they come to the
Yes.
page?
This is also 2018 matter.
Yes, that's why. Although the matter is so simple, in view of involvement of so many parties, the government, village council, and the private respondent petitioner. So the matter taken for such a long time. Otherwise, it should have been decided in one call. Page 14
Page.
of the writ petition.
Yes.
This is the money receipt.
Page. Just wait. Page. Page 15.
14. That is the type copy.
Your
Money receipt.
your
My writ petition.
Just wait.
So many affidavits have been filed.
I know.
And after that, again, we have filed reply, so it becomes little bulky.
Page
14. That is the type copy of the money receipt. That's what Lordship Padi.
Yes.
Received rupees 5 lakhs from Pinatung OTU of Pukotam as advance for purchase of land about 14 to 15 acres at Irrelevant Colony, Dimapur on 8/1/2014, and the remaining balance amount will pay within March 2015 as discussed. And then on the right hand side, the signatures, that is the seller, Rahul Samada.
This seller is the respondent number 6.
Yes, correct, Lordship. And thereafter, as discussed, in the next page, Lordship will find the land for sale in the bottom of the page, in the middle column. Second column from the extreme right, land for sale.
Land for sale. This
26
26 because
Yes.
at Irali bill,
Irrelevant Dimapur.
rupees 60 per square feet.
Yes, Lordship. That was how the notification application was made.
This is advertisement, correct?
Yes.
Advertisement.
Yes. In the Nagaland Post.
Correct.
And then next page.
Anyhow, who has taken the steps for advertising?
The petitioner.
The petitioner.
Yes. That was the understanding.
Okay.
And the next page, page number 3.
Page
Page 17.
17.
Annexure 3.
Page 17.
It's a
Yes.
type copy, Lordship.
Yes, wait. Okay. Page 17. What is this?
This is by the petitioner, Dear Rahul. As discussed on 8/1/2015, I am ready to pay you the balance amount for which you have already taken total rupees 5,70,000 only as advance against your land pata at Irrelevant Dimapur. So kindly hand over to me a copy of Xerox for each pata for necessary verification. And if you fail to do so on or before 25/6/2018, I have no option, but I will have to file a case against you to the agency or government to settle the case. That was written on
Yes,
24 6
Mr. CT,
2018.
Mr. CT,
Lordship.
for my better understanding, please come back to page 14. This 5 lakh,
Yes.
this 5 lakh was the earnest money for 14, 15 bighas of land.
Yes.
The advance deposit,
Yes.
14, 15 bighas of land.
Yes.
Okay.
And then 17 is the what?
The letter.
I'm asking
Uh,
for a Xerox copy
Can
of
we
the
hand over me the
pata.
for each pata, the copy of Xerox for each pata.
Yes.
Maybe the land is in the separate pata.
Yes. Now kindly come to next page. Like the Hindi film where we are
Yes,
coming
yes.
to the real show.
It's more
This is the impune order.
more interesting than Hindi film. Page 18.
Yes, this is the impune order. It was issued on 16 July 2018 by the Irrelevant Village Council, Office of Irrelevant Village Council, Dimapur, Nagaland. Summon order. And then may I read the letter? As per the written complaint received from Srimati Praditi Sangma, that is the mother of the respondent number 6, who is respondent number 5, of Irrelevant Village, against Sri Pinathong Otiu of Upatau on land dispute case. The subject matter shown is very clear that on land dispute case. You are hereby directed to appear present personally, physically at Irrelevant Village Council Court. Here also court is clearly mentioned. Irrelevant Village Council Court on 4th August 2018 at 10 a.m., failing which the court shall take its own course of action. So the petitioner is agreed by this, and then this approached the honorable court, and at the time of motion, the honorable court was pleased.
This is the only impugn summon?
Yes. On the two grounds. Number one, next page is the government notification of 1989 about the constitution and appearance of the customary courts. And this lordship is aware. Lordship have been dealing with, so I need not waste time on this. So someone has clearly mentioned that it is about a land dispute case.
Correct.
I have stated in my paragraph that there is no land dispute at all. It is not a land dispute. And in paragraph 12 of the affidavit of respondent number 5 and 6 also, they have categorically stated that there is no land dispute. And if at all there is any land dispute, such a dispute can be decided by the Deputy Commissioner since he has issued the pata and it's falling within the cadastral area of Dimapur Mauza. So Deputy Commissioner is the right authority, competent person, jurisdiction.
Have you enclosed the patas?
No, I have not, because he has not furnished.
Okay. Anyone representing the private respondents? Okay, good.
So if I participate and listen to the summons, it will amount to submitting to a jurisdiction which do not have the power to adjudicate. So that is the only case. Very simple issue.
Yes. Yes, government. Yes. You first leave aside the others. You first justify as to whether the village council can issue such summons and under what provision, if so. Yes.
Lordship here.
You may be thinking that this is a dispute between private individuals.
Yes.
But this court has a very pertinent question to ask.
Lordship.
Whether the village council has the power to issue such summons. That is the only question which I want to get from the government. Section 14 has been done away with. You have taken away the adjudicatory powers of the village council. Yes.
Lordship, I'll leave it to your Lordship says. Lordship knows better, Lordship.
No, it's not a me knowing better, but because actually you have to at least justify as to why the village council have issued, because it is not for the private respondents. They may have their right so far as the land is concerned. But the petitioner is aggrieved only by this impugned summon notice. So whether this court is asking you whether the petitioner, the village council has the power to issue such summons in a land dispute.
Lordship, I have no received instruction as far as the case is concerned, Lordship. Despite of some letters. So on my own, maybe not very appropriate to make any submission beyond than that. Lordship.
No, we now here our discussion is not on facts. It's purely on law, as per the Nagaland Village Council Act. So whether a reading of this act will show that the village council has the power.
Lordship, I'll be honest with my Lordship, since I was under the impression that this is more to do with the private parties. That is why I've not gone through it seriously to make a substantive submission, something that may be silly.
See, Mr. Kiangami, please don't come with that impression, because actually here is a question where actually the summon has been issued by a statutory body. Which institution is functioning under the government? So that's why this court wanted to know. Because this court will not go much into the facts. This court has no power to go into the facts and then to say that this person has the right over the land, or that person has the right over the land. No. The only limited question raised by the Learned Counsel for the petitioner is that the village council does not have the jurisdiction to issue the summon order. This is the only issue. And for deciding this small issue, I think we have been lingering since 2018. I think, yes, Mr. Lima.
Yes, Lordship, I'm representing the village council.
Yes, so.
Lordship, I filed an affidavit.
Huh.
Lordship, may kindly come to my affidavit, just one annexure.
Yes. Your affidavit, respondent number?
Respondent number 4, Lordship.
Yes, wait. Respondent number 5 and 6. Respondent number
4.
Yes, wait, okay.
Albert. Yes, Lordship.
Yes.
Lordship, in my affidavit, I have annexed just one annexure. Lordship, page number 7. In the type copy is at page number 8.
Which one?
Page number 7.
Page 7.
Yes, Lordship, in the type copy is at page number 8.
Page 7. This letter?
Yes, this is a complaint which I have received from the Grandi
Page 7.
Sangba. From
This
respondent
is
number
complaint dated 18/6/2018.
Yes, Lordship, this complaint was written by respondent number 5 to me.
Grandi.
Grandi. Lordship, may I read the contents of the letter?
Yes, please.
To so and so, Lordship, subject. This is to bring to your kind notice that some land belonging to me in my relatives were sold to Mr. T. Sipiba Sangdam, son of late Swinsu of Prana Bazar. However, Mr. Pinatang Utyu, that is the petition also, from Oka down, is demanding and pressurizing for commission of the said sold land from my son, Mr. Swinsu. Mr. Rahul is a respondent number 6. Hence, I urged and request the village council, Iralibil Dimapur, to kindly look into this matter, as I am undergoing severe mental and physical stress due to this issue. Bishop, this is not a land dispute issue. The issue involving the prison rate petition.
No, but the
Respondent number 6.
But the summon. What about the summon?
Yes, Lordship.
Summon says land issue, land dispute.
Yes, Lordship. Someone says, but Lordship, this is a complaint. And Lordship, the fact is this: respondent number 6, he sold a plot of land through the initiatives of the writ petitioner. which he has issued a paper publication also, inviting the customers. Out of the sixth seal, he's asking for commission, land sale commission.
Maybe that issue this court will be handicapped to decide.
Your Worship, I'm not pressing on that. As my learned senior friend has submitted, the very limited question is, Your Worship, whether the village council he have the jurisdiction to issue the summon or not. As Your Worship as rightly pointed out.
And even otherwise, the village council does not have the power to decide any issue regarding transaction.
No.
Transaction regarding transaction. Suppose this respondent number 506, if this respondent has written a letter to the village council saying that his son has been duped or his son has been cheated, the right recourse is for the village council to actually furnish the letter to the officer in charge. Yes.
But Worship, this is only a summon. He may see so after appearing before the village council. After appearing before the village council, he may express his opinion. After we can take the appropriate steps. We may even, if appropriate, we may refer to the district administration. But he's refusing to come to the village court.
No, why should he come? The question is, why should he come? Why should he come? The question is, because actually, see, Mr. Lima,
yes,
because once the complaint has been lodged, we are actually not like discussing on the merit.
No.
But once a complaint has been lodged by the respondent number 6 against the petitioner, maybe saying that some demand has been made with regard to some land transaction and all this. I think the right recourse is for the village council to refer the matter back to the officer in charge. You know it.
But Worship, regarding the jurisdiction, whether the village council has the authority to issue the summon to compel attendance of witnesses. Worship, I'm allowed to refer just to 2 sections. Worship is well aware. For administration of civil and criminal justice, the role has been framed under Chapter 3 and 4 of the 1937 rules.
Yes.
Worship, they are empowered under this rule.
Yes.
Worship, as per the complaint which I have received, Worship, is a mixture of criminal and civil offense. Allegation is the petitioner is threatening the family of respondent number 6 and 7. Worship, in respect of criminal justice, Worship, I'm allowed to refer to section 19. 17E empowers the village authority to take up the criminal cases. Worship, 17E in 19. Under the criminal justice.
Yes. Tribal courts.
May I read section 17? Mauzadar, Kamburas,
Section
Chief.
17. Yes.
Section 17. Mauzadars, Konburas, Chief Hitmen of Kill, Topashis, or other village authorities. The village council come under this Worship. Sitting with the village elders in council may dispose of cases in which persons are charged with any crime which is not heinous. And Worship, I can come to section 17E.
You read that below also. They may impose a fine
Worship, yes,
for any offense they are competent to try to the extent of rupees 50.
They may award restitution or compensation to the extent of the injury sustained and enforce it by the extent of the properties of the offenders. In case in which the fine is not paid or realized, either in whole or in part, these shall represent the facts and send in the offenders to the deputy commissioner, who may retry the case, impose such other punishment as he is competent to inflict.
Mr. Yes, Lima, as per section 17, which you are reading.
And
you have the power to impose a fine of rupees 50. Nothing more than that.
Worship is a 1937 laws, Worship. And Worship is under section 19.
Section
19.
Especially the proviso.
Worship, with regard to the compelling of attendance of witness is prescribed under 19.
No, but we will not go into all this because actually we will go by the impugn. What is the impugn order? What is the impugn order? Impugn
But-
order is a summon.
It's a summon.
It's a summon to discuss
compelling him
land
to
issue.
Lordship, is not a land issue.
Do you see the summon? Let us see once more. Let us see this. See, some cases are such that even how hard you try to twist, we land back to the same again circle, the same point. Page 18.
Page 18, Lordship.
Ah. As per the written complaint received from Srimati so-and-so against Sri so-and-so on land dispute case.
Here's mentioned
You
land
are
dispute.
hereby. Okay.
But Lordship, when we see a copy of the complaint, from the copy of the complaint, it's not a land dispute case, Lordship.
It is
He's asking for commission, land sale commission.
Okay. We will take note of your small submission, but
Lordship, kindly proceed to section 19. Since it is regarding the compelling of the witness to attend, under section 19 is involved.
section 19.
Section 19. You should merit section 19,
I have not got it. Section 19.
page number 19, page also 19.
This is village council, correct? Page
No,
number.
Lordship, under 1937 rules. No, Lordship, you're referring to the wrong book, this book, 1937 rules.
Oh. Page.
Page 19. Section 19.
Page.
Dear Lordship, the Mozadar, Kambura, chief hitmen of Til, Toposhis, or other duly recognized village authorities shall not decide any case, save in open papers in presence of at least 3 witnesses in the complainant, in the accused, whose attendance they are empowered to compel. By this provision, by this very word, the village authority they are empowered. Lordship. And Lordship, regarding this, Lordship, again, yes, Lordship, I will refer to that book. Section 15, Lordship.
Yes, but section 14.
Lordship,
Section 14.
You see, section 14, it was omitted.
Yes,
Lordship,
omitted.
by-
And what is the subject matter of that section? To administer justice.
Justice. Lordship,
So section 19 is to administer justice.
Lordship, section 14, it was omitted, but by 5th Amendment, that was notified only last year. Again, by 5th Amendment, the section 14 has been brought back.
Where is that amendment?
Lordship, sorry, today I didn't have the copy.
If not, you have, Mr. Sikhi.
No, Lordship, I don't have. But then, even without that, going by section 18, rule 18, clause A and P, there is a bar. When I'm not a resident of that jurisdiction, there is a bar. By reading 18, Mozadars, Conquerors, Chief, Head of Kills, Dobashis, or other duly recognized village authority may carry out their decision or order attachment of property as soon as judgment is pronounced. But in no case is property so attached to be sold if the party convicted claim to appeal within 30 days without the order of the Deputy Commissioner, Maujadar, Conquerors, Chief, Head of Kills, Gabashis, or other duly recognized village authorities may not decide in cases under A. When the defendant is not a native of Kohima, Mokokchung, Tuensang, Oka, petitioner is a resident of Oka, Senebutu, Pek, and Moon, or is not resident within their jurisdiction. They cannot. I'm not a resident of that particular village who has issued the summons.
Mr. Lima, if the village council has any grievances, let them forward the complaint to the police. Nothing more.
But Lordship, if we see section 15 under this Nagaland Village Area Council, no transfer of immovable property shall be effected without the consent of the village council. It is a specific provision. If the petitioner is claiming it is regarding a land dispute, you should make a kindly appreciate section 15. Section 15 only. The village council shall be auxiliary to the administration and shall have the full power to deal with internal administration of the village. And the present issue, is an internal administration regarding.
How can you just drag in?
No, Lordship. Lordship, if you see the affidavit filed by one number 5 and 6, the petitioner, he even came and treated your family.
That is why, if the complaint has been lodged to you, you could have actually endorsed the case to the police. Nothing more. Yes, madam, you are for.
Lordship, in my paragraph 3 of my affidavit in opposition, Lordship, I have narrated all the facts as to how the petitioner has filed the complaint, Your Lordship. How the respondent number 6 has filed the complaint, Your Lordship. Lordship, the petitioner has been intimidating, harassing, abusing the family members of the petitioner numbers 5 and 6, Your Lordship. I've narrated everything in my affidavit, Your Lordship. He was creating law and order when he was disrupting the peace of the house, Your Lordship. So the petitioner filed a complaint before the village council, Lordship.
Have you taken money? 5,70,000.
Lordship.
Have you taken that money? Are you admitting?
Lordship, the petitioner has expressed his intention to buy the land, Your Lordship.
No, have you received the money?
Yes, Your Lordship, 5 lakhs. And thereafter, he was not able to give the full amount, Your Lordship. So he didn't want to take back the money also. He wanted interest 20 to 30% per month till from 2015 till 2018, Your Lordship. He was asking for commission, Your Lordship. That was the case. And that's why he was sending his henchmen to the residents of the respondent 5 and 6, creating havoc in the house, Your Lordship. I've read all in my, but it was, even in the absence of the respondent number 5, he would come to the house of the respondent number 6, the mother, harassment, Your Lordship. That's why the petitioner filed a complaint before the village council. Now, Your Lordship, of course, the word
We will
is...
give a direction that if you have any grievances,
Yes, Your
or
Lordship.
if the petitioner is threatening you, to take recourse to law by filing a proper complaint. But so far as the challenge to the impugn order is concerned, I think we may not allow the
Lordship,
village council to adjudicate.
Lordship, he was creating law and order problem by trespassing into the house of the petitioners and harassing, abusing the people, Lordship. And the village council has the power to oversee maintenance of law and order, Your Lordship,
No,
as per
obviously.
as per section 15. So if Your Lordship, if the summons is interfered with, Lordship, which that means the village council has no authority to oversee
That means
maintenance of...
this court will just keep the summon like that so that you can adjudicate a land dispute.
No, there is no land dispute. Even I have stated in my...
We go by the notification, we go by the order. See, you may say so many things, the other side may say so many things, but this court will go by the records. Nothing more.
Lordship, if we see the
And if you still agree, if you still feel that actually you will be harassed, you will be treated, this court may give a rider saying that if anything of such thing happens, then you can approach the law enforcing agency. But at this juncture, to allow this summon to stand, maybe I think this court will be doing something which is not within its jurisdiction.
Lordship, the harassment and the whatever it
But
is,
that's
it
why-
was because of the commission. It was arising out of the claim of commission from the land proceeds. So because of that, maybe the land
No,
dispute. That was the reason.
even
Yes,
if
Your
we
Lordship.
take your submission to be true, where is the power of the village council to adjudicate such matters? Because
Yes, Your Lordship.
actually,
I agree, Your Lordship.
such
Village
matter is to
council,
be adjudicated before the law enforcing agency or before the court.
land
But,
dispute, the village council has no authority.
No, not even land dispute, even the transaction. Even the
Lordship,
transaction. More so when
Lordship-
the petitioner is not a resident of that village. More so.
Lordship, when the petitioner was coming and harassing and abusing the members, the village council has the authority to at least someone and explain his conduct, Your Lordship.
He is not a resident of your village. You could have actually, as a village council, the village council could have transmitted the matter to the police.
What is the incident happened inside the village council?
You
within the
missed so many
jurisdiction, Your
things,
Lordship.
but this court, we go by law. We go by law. Okay, we pass the order, small order. We pass
Lordship,
the order.
but protection may be given to me, Lordship, so that the petitioner will not come again and
About the Mahendra
so
Singh
that the
case.
petitioner again would not come to my residence and
See.
harass me again, Your Lordship.
No,
Protection
no,
may be
no.
given, Your
Even
Lordship.
if this court gives a direction or not, if the petitioner comes and harasses you, threatens you, then you have all the discretion at your disposal to approach the law enforcing agency or for that matter the court. Okay, we pass the order, but maybe it may take 2-3 days because we will be a little bit busy. Okay. Yes. Please call the steno. We will. Yes. You know the item, ma'am? Item. Item.
Eight.
Eight. Heard Mr. C.T. Janya, the learned senior counsel, assisted by Mr. I.M. Chin, learned counsel for the petitioner, Mr. Kiangami, the learned senior government advocate for the state respondents, Mr. Lima Wabang, learned counsel for the respondent number 4, and MS Esther, the learned counsel for the respondent number 5 and 6. Okay, keep it in the file. Okay, type out and keep it in the file. I just want the names. Okay.
Lordship, Lordship.
Okay. And this also, this book also. Okay.
For hearing, item number 9.
Yes, what is this, Mr. Moa?
The matter pertains to compassionate appointment.
Compassionate appointment.
This is the fourth round of litigation before this another court. Right? I think the peculiarity of this case is that the government has taken a decision on 16 August 2021, Lordship.
2000?
2021.
2021.
Stating that since I belong to a non-indigenous inhabitant, Lordship, that scheme for compassionate appointment will not apply to me. That is the grievance in this case. Otherwise, on the earlier 2 occasions when I approached this honorable court by failing to read, Lordship, this court has given direction to the respondents to consider my case as and when vacancy arises, Lordship.
But you are not an indigenous.
Yes, Lordship, I agree that.
You are not an indigenous, and I think leave way for indigenous people.
Lordship, my contention is Lordship, the compassionate scheme is a special policy for the employees, Lordship, who die in harness, Lordship. Lordship, I also agree that there is a special scheme, Lordship, that reserves only 20% for non-indigenous inhabitant, Lordship. In the year 1973, Lordship, there is a policy, Lordship. And as part of policy, Lordship, 20% is reserved.
What is the latest policy? Any latest policy?
Lordship, that is the only policy that has been produced by the government, Lordship. As far as the general recruitment
Yes,
is concerned, Lordship.
Madam, what is the latest policy?
Lordship, in my affidavit, annexer,
What is that policy dated and what is it?
Lordship, may kindly allow me to read. Lordship, under the present policy decisions of the government, non-locals are not eligible for employment against the reservations made for the indigenous inhabitants of the state. They are, however, eligible for appointment against 20% of the vacancy relating to gazetted technical posts. Lordship.
Now, the issue is whether this 20% will apply for compassionate appointment.
Yes, Lord. That is evil.
Unless the government has a decision, I think.
And if the Lordship may also kindly appreciate in both the policy Lordship, compassionate appointment does not also say about that 20% will be applicable in the compassionate appointment.
Hmm.
And Lordship may also kindly appreciate all over the country, Lordship, such kind of policy is not applicable for compassionate appointment. This is a special scheme, Lordship, for the employees who die in harness, Lordship, in order to mitigate the hardship that the family members goes through, Lordship, on the sudden death of paid earner in the family, Lordship. I agree that the general policy is applicable. I'll apply only for that 20%. That also technical post, Lordship. But as far as this compassionate appointment is concerned, my respectful submission is that that should not apply for compassionate appointment.
Who is the disease employee to you?
My father, Lordship. He was serving as a Nayak, Lordship. He passed away in the year 2008, Lordship. And this subject matter, this contention has been raised only for the first time in the fourth round of litigation. The state was silent on the
2008.
Yes, Lordship, 2008.
2008.
Yes, Lordship, 2008. Lordship.
Now it is 2024.
Yes, 16 years, Lordship, 16 years.
Are you still, does the cause of action still survives?
In fact, while pending
Because
all this litigation,
compassionate appointment is for.
Yes, Lordship. Supreme Court also very clear, Lordship.
What is your first? When was your first writ petition filed?
2017, Lordship. 2017. In fact, if your Lordship may also kindly appreciate that the action issued by the state, this honorable court, Lordship, in the the second writ petition, the government has filed the affidavit and produced on report showing the vacancy list at that relevant point of time, and this honorable court has given a direction at least to accommodate in those out of 6 vacancies, Lordship. That was the direction. The only thing was that there was no time frame, Lordship. That is why on filing contempt, this honorable court.
So what happened to that list? What happened to that list?
The state is silent on that, Lordship.
What happened to that list, madam? You have produced a list saying that actually he is in the line. What happened to that?
Lordship, I have it in the previous occasion also. I have already submitted the record. The petitioner is at serial number
It's your case.
7. But however, Lordship, as per of his memorandum dated 19 April 1993, he is not an indigenous, so he's not eligible for employment, Lordship. However, Dindi person is eligible, but Lordship, it is parted into mention that Lordship. It is part of the mention that by letter dated 16/8/2021, informing him that in view of the observations of the B and AR department, the Office of the Director General of Police, on the result of his documents, the case of the petitioner cannot be considered since the petitioner does not have any technical qualification as required by the Office Memorandum No. AR 8876 dated 19/4/1983.
19/4?
19/4/1983.
What is that 83?
Lordship, Annexer B in my affidavit.
Okay, the first question is why did you appoint the father of the petitioner? Why did you appoint?
Lordship, for that, allow me to take some instruction, Lordship.
Why? You are appointing the father and you are saying that the son is not entitled to die in harness scheme. I think that's, something horrible. At the first instance, if the father is not non-indigenous, why appoint him? You have appointed him. Now, actually, the son has a legitimate expectation.
Moment, if I may allow to refer to the direction issued by this honorable court, page number 31 of my petition.
Yes. Just wait. In that first case, no? Just general knowledge, no? Yes, yes, Mr. Moore.
Page 31, Lordship.
Of your
Read petition, Lordship. This is the order passed by this one of the board, Lordship. 16A, page 31, annexure J, Lordship. Amended petition, Lordship. There's an amended petition. Page 31, Lordship. The Lordship got it?
yes.
This is 2 pages order, Lordship.
That's all right. That's all. Now, what is the latest? What is the latest position in the department? You include the petitioner. What is the latest position? Because actually, there's an order passed by this court, judicial order, and you have appointed the father of the petitioner, assuming that he is not non-indigenous. Why have you appointed him?
Lordship, for that I have instruction. So a lot with this.
No, we are not giving much this thing, but we are asking you to produce the latest. What will be the position of the petitioner in the list for completion of the point in the department? You produce that.
Lordship.
You produce that. That has to be. If not, we pass order to appoint the petitioner within a specific period of time. Okay.
Lordship.
You produce that. You produce, because actually all this judicial during all this judicial proceedings, you have not taken this position. It is only now after 4 rounds of litigation, you are coming and saying that he is not an indigenous. Maybe I think this court will not accept that. Heard Mr. Jamir, learned counsel for the petitioner, and MS Pichano, the learned government advocate for the state respondents. In the course of the hearing of the writ petition, this court desires the government advocate to produce the following instructions on the next date fixed. Notification, number 1, notification issued by the government stating that the compassionate appointment is not applicable to the indigenous persons.
Non-indigenous.
A non-indigenous is not applicable to the non-indigenous persons. And 2, the latest list of the persons eligible to be appointed on compassionate appointment in the department, which will also include the position of the petitioner. Stop. The instructions sought shall be placed before this court in the form of an affidavit. Listed after 2
After
weeks.
2 weeks, Lordship.
Listed after 2 weeks. We'll see.
I will fetch.
For hearing, item number 10.
Yes.
One of the petitioner, he was
What is your case?
police personnel. He served for 14 years, 11 months in 3 days. Then he took a voluntary premature retirement. Because he had to look after the village. His father being the head Kangura, which is a statutory party in the state of Nagaland. However, he was not paid any retirement benefit. For that matter, to entitled for pro rata pension, somebody must serve minimum 10 years of service. The petitioner served 14 plus years. So what I bring before Lordship is to release that to be
What is the nature of your detachments from service?
My Lord, I just applied for discharge. Accordingly,
You were discharged.
yes, by the competent authority. It's not the leaving the service.
What? Not leaving the service?
It is not a question of desertion. I took due discharge from the appointing authority. That is the competent authority. Stating that because of the family problem, yes.
What is the legal meaning of discharge? What is the legal meaning of
My
discharge?
Lord, yes. Once somebody took a discharge, the question will come under what provision of law? That is, discharge is recognized in Rule 5 of the pension rules. That is, regulation of pension or family pension, any claim to pension or family pension shall be regulated by provision of these rules in force at the time when the government servant retires or retired or is discharged.
Or is discharged?
Money. Or is allowed to resign also. Of course, my case will be discharged from service or ties, as the case may be.
What is that rule? Read again.
Rule 1972's pension rules. Swami. Rule 5 is, my Lord, I've extracted that in my reputation, page 8 of my reputation.
Let me see the book. See the book.
My Lord, my reputation, I've extracted that portion, page 8 of my reputation. Para 6, CC's Pension Rule 72 provides Chapter 2, General Conditions for Pension. Rule 5, Regulation of...
What pension? What is the nature of pension?
It can be either one. Retirement pension, that is after a certain age, or
premature pension.
Yes. Other is invalid, disability.
You are not under that?
No. I'll come under that discharge. So what if construed it as resignation? Even the resignation, when somebody have to qualify and let that service, that will come under Rule 49. 2. So I have inclusive as an exercise.
Read that provision. Read once again. This, Mr. Muzui, this was actually an issue even in some other petitions.
In this petition.
In this petition, Lordship.
In this-
Lordship, if Lordship will remember, the Honorable Court has directed the AG to clarify and file an affidavit. Lordship, by order dated 5/10/2023. So we have sought for justification, clarification from the Office of the Accountant General. And accordingly, the AG has written, Lordship, in my affidavit, Lordship, which I have additional affidavit, Lordship, which I have filed on 8 November 2023. Now, as per the query, the first query was whether a government servant who has been voluntarily discharged, a specific query was made, Lordship, who has been voluntarily discharged from service at his own request after serving for more than 10 years,
is entitled to pensioner benefits. One. Second query is whether a discharge from service and resignation from service is one and the same in regard to the entitlement of pension. These are the two queries put up by your lordship. So in the first query, the reply that came to us, lordship, and it's in the affidavit, lordship, a government servant who has been discharged, resigned from service on public interest, lordship. This is important. On public interest by the authority is entitled to pension benefit. However, an employee can voluntarily go on retirement after completion 20 years or qualifying service under CCS pension rules. That is Rule 43.
What is the qualifying service? 20 years?
20 years, voluntarily. 20 years, as per the CCS pension rules. He should at least complete 20 years of service.
That is voluntary.
Voluntary. Now, those government servants who quit, resign, discharged from service at his own request is not entitled to pension benefits. So this is the query given to by the AG. On the second query,
any provision of law cited?
Lordship, they have just quoted the Rule 43. That is with regard to the voluntary.
Voluntary?
Yes, Lordship. Now, Lordship, going by even by the writ petition, the discharge order is annexed in the writ petition, Lordship.
In the service book, which I don't know.
Yes. Now, Lordship, Annexure 3, page 43 of the writ petition.
Just wait. Annexure 3.
Page 43 of the writ petition.
Page 43, Annexure
Yes.
3, page 43. Of the writ petition, page 43.
Lordship. This is the discharge certificate.
Page 43?
Yes, Lordship.
Annexure 3?
Yes. Page 43A will be the type copy, Lordship. Now, Lordship, just before that, the application of the petitioner at page 42, Annexure 2, the type copy is at page 42A. So, Lordship, when the matter was heard before, basing on his application, this query was put up because it was on his own request to the commandant. So and so, Lordship has found discharge from service. I have the honor to state the following few lines for favor of your kind consideration and necessary action, please. Sir, since so and so till date, I am serving under your kind command with so and so, but due to some unavoidable circumstances, that my father is old age and there is nobody to look after him. Therefore, I earnestly request you may kindly discharge me from service as domestic problem.
This is voluntary. This is voluntary.
Voluntary.
So what does
and Rule 43 says 20 years minimum.
Or voluntary?
Voluntary, yes. So on that query, Lordship.
Let us see that rule. This I don't know, but in this pension text, textbooks, different page for different author.
Yes, Lordship.
And I think even the provision, I think it's a little different.
Yes.
Page 24. Page. Rule, which rule?
Voluntary. Now, another thing that is confusing the entire proceeding is, Lordship, he was issued a discharge certificate, but no reason cited.
Yeah, but actually that his application and the discharge order has to be read together.
Yes. So if that is read together, that means on his own violation, on his own, he has asked for discharge from service.
So I have understood to that extent.
Yes.
So voluntary service, this thing, at least 20 years of service.
Yes, 20 years.
So where is that?
20 years. The CCS, Lordship, I'm very sorry, I don't have produced.
voluntary 20 years, I have no dispute about that.
40, pension rules 43.
43.
Swamis.
Lordship,
This says
they-
pension rules.
Yes, Lordship, but they have not
Yes,
quoted
same,
the
my lord.
author. But most of the books rely with Swami.
Pension rules. Rule
43.
Which is already delayed, man. 43 to 46, already delayed.
42 to 46 deleted.
Yes. 47 also. So what will happen is this, my lord. In case,
Now, if 42 to 46 is deleted,
yes,
do we have to take recourse to the all rules 10 years?
we'll go by 49, rule 49, man. 49. Amount of pension. One is gratuity. Malo 49 sub rule 2, subject to the proviso of rule 2, in case of a government servant retiring in accordance with the provision of these rules, that is permitted under rule 5, after completing qualifying
But
service.
this is a question of retiring.
Yes.
Yours is a discharge.
My lord, through rule 5, which I have read out, this is general
Pension
conditions for
rule,
pension, that is regulation of claim for
49.
pension, that is rule 5. So somebody can take the charge. The question then, whether somebody has completed a certain period of service.
No, Lordship, basing on the CCS pension rules, the query number 2 has been answered by the Office of the Accountant General, Lordship, where it says that in the case of civil government servant, the term discharge and resignation from service are treated as same. In both terms, pensionary benefit will be entitled if it is in public interest. If a person is released, allowed to resign or discharge from service in public interest, then he will be entitled for pension benefit. But the pension benefit will not be given to those who have resigned on its own
That is why,
request.
where is the provision which says that public interest?
No, my lord, that is what I'm saying.
The provisions, Lordship, as far as the explanation is concerned,
Come prepared next time. Provisions. I have been asking you repeatedly, Mr. M. Muzui.
Lordship.
You are just giving me a picture, but you actually have not been able to explain what is inside the picture.
Lordship, the AG query, the query of the court given by the AG is on the 20 years.
No.
You should-
That's why
Yes,
on the queries with the relevant provisions at least.
yes, Lordship. Lordship,
Yes, we'll fix it some other time.
Lordship.
We are silent on rule 49 too, my lord. If we are clear on rule 49 too, this after report question of giving clarificatory or other doesn't arise. If they are clear about rule 49 too,
You yourself, you are not clear on your subject. You are not being able to make a definite submission. This court is confused.
Lordship, sometime maybe later, Lordship, I'll clarify to that point, Lordship.
Kindly come with actually the complete rules. Not on this, Swami. This here, there are some.
It's always confusing,
It's
Lordship.
confusing.
Yes,
So you kindly prepare a small chart.
Lordship.
This section, this rule, this. and because of which he is entitled or he is not. Kindly come with that chart. Oh, I think we have been lingering on this case for quite some time.
Yes, Lordship. I understand, Lordship.
And unless the person sitting here is quite conversant,
Lordship.
it will be difficult to pass any order.
In fact, Lordship, the issue involved is very technical, Lordship, on the interpretation of the pension rules.
And then, you are saying that resignation or discharge, correct?
Yes.
In public service.
Yes.
In
If
pub-
they're
in
discharged.
public service.
Yes. In the interest of public service, if they
so-
are discharged or they resign.
Correct. They are eligible.
Eligible. But when a person on his own,
Huh.
that comes under voluntary again. That's what basically the AG is trying to say.
That's what I want all these things. So.
Lordship. I'll get more clarification on this again.
Mr. MT also kindly roll out a chart for me.
We'll do that.
I'm a little confused with this. Next week, no. Next week.
Oh. Next week is Puja break. Yeah.
Let us listed on 17 again. Come, properly prepared for me to dispose. If not, it will be difficult for me. Listed again on 17, 10, 20, 24.
Lordship.
Yes.
Oblige, Lordship.
Anything more? Okay, over.